students, this is Tulika Banerjee from Forensic Science Unit, SGTB Khalsa College, University of Delhi, presenting this module on behalf of Ms. Deepika Bhandari and Mr. Milind Mishra from Institute of Forensic Science, Mumbai. I am delighted to present this lecture on cyber crimes and adjudication of cybercrime in India. Before we start our chapter with the introduction of this chapter, let's look at the other modules we will study in this chapter. Module 1, Introduction to Cybercrime. Module 2, Information Technology Act. Module 3, Adjudicating Officer and Cyber Regulations Appellate Tribunal, that is CRAT. Module 4, Adjudication of Cyber Crimes in India, and Module 5 is the conclusion. What is cybercrime? Today we all are living in the age of information. It is also called as digital age, where all the needed information is available on a single click of a button. It is possible because of internet. We all are connected to the world using internet. Today, communication is so fast that one can send messages or mails anywhere in the world within seconds. Internet is the biggest revolution of the present times. It has made life easy, especially for the purpose of doing businesses. Business organizations can do their business using e-commerce. They can exchange their documents using the electronic documents interchange, that is EDI, transfer money electronically using electronic fund transfer, that is EFT. Even the government is providing their services like all types of tax payments by means of e-governance, so that one can pay their utility bills like water or electricity bill. One can book railway, airline or movie tickets by sitting at home within a minute. Internet has changed our lives drastically. It has made easy to store, create, process, transfer documents in electronic form instead of traditional paper-based documents. It is a faster and cheaper way to store documents in electronic form, pay utility bills, etc. It is now easy to get most of the government and non-government services now. Though internet has many advantages, it has disadvantages also. People are using it for wrong purpose as well. People are misusing for getting some financial gains or to harm others or spreading their ideology or for harassment. Nowadays, most of the criminal activities are happening around the world using computer and internet. Cybercrime is such a crime where computer is coupled with internet and they are involved together. It also includes traditional crimes in which computer and computer network is used. For example, credit card frauds, where frauds happen by getting personal information from the internet user by sending fake email in the name of bank and using this credit card information to make online shopping, distributing child pornography, shutting down computer of networks by means of hacking into one's computer, etc. In cybercrime, either computer or network or internet is involved. In this type of crime, either computer is used to perform the crime or computer may be a target or a victim of crime. Cybercrime is classified into three categories. The first one, crime against individual, that is person and their property. The second type, crime against organization, that is government, firm, company or group of individuals. Third type, crime against the society at large. Let us discuss them in brief now. That is, first one is cybercrime against person. It includes harassment via emails or social networking sites, cyber stalking, dissemination of obscene material, defamation, hacking, cracking, email spoofing, SMS spoofing, etc. The second type, that is cybercrime against government. It includes cyber terrorism, cyber warfare, distribution of pirated software, possession of unauthorized information, etc. And the third and the last type, that is cybercrime against the society at large. It includes child pornography, cyber trafficking, online gambling, financial crimes, forgery, etc. Cybercrime or offences are unlawful act in world as well as in India. There was a need of law to tackle such type of offences. There was no such law existing before 2000 in India to tackle such types of crimes. So, Indian Parliament has passed the law to tackle cybercrime and e-commerce in the year 2000. This law is called Information Technology Law 2000, that is IT Act 2000, which was based on United Nations Commissions on International Trade Law or the UN CITRAL. India was among the 12 nations in the world to pass such type of cyber law. IT Act 2000 came into force from 17th October 2000. IT Act has 13 chapters and 90 sections, and section 91 to 94 deals with amendments to the Indian Penal Code 1860. IT Act 2000 further amended the Indian Penal Code 1860. The Evidence Act 1872, the Bankers' Books Evidence Act of 1891 and the Reserve Bank of India Act of 1934. Digital evidence to be collected and proven as per the Indian Evidence Act of 1872, the Bankers' Books Evidence Act of 1891 and about bank record. IT Act 2000 was further amended in the year 2008, so at times is also known as Information Technology Amendment Act of 2008. IT Act Amendment 2008 covers information security, cyber cafe, Indian Computer Emergency Response Team, identity theft, cyber terrorism, child pornography, legal reorganization of digital signature, authorization of as inspector, as investigating officer for cyber offences, etc. Parliament has passed various rules related with information technology, like Information Technology, Procedure and Safeguards for Interception, Monitoring and Decryption of Information Rules 2009, Information Technology, Procedure and Safeguard for Monitoring and Collecting Traffic Data or Information Rules 2009, Information Technology, Procedure and Safeguards for Blocking for Access of Information by Public Rules 2009. Let us now see the list of offences and sections under IT Act Amendment 2008 and IPC. In this table, on one column we have shown the offences and on the second column we have shown the section under IT Act. Tampering with computer source documents covered under section 65. Hacking with computer systems, data alteration covered under section 66. Sending offensive messages through communication service, etc. under section 66A. Dishonestly receiving stolen computer resource or communication device under section 66B. Identity theft under section 66C. Cheating by personation by using computer resource, section 66D. Violation of privacy under section 66E. Cyber terrorism under section 66F. Publishing or transmitting obscene material in electronic form under section 67. Publishing or transmitting of material containing sexually explicit act, etc. in electronic form under section 67A. Punishment for publishing or transmitting of material depicting children in sexually explicit act, etc. in electronic form under section 67B. Preservation and retention of information by intermediaries under section 67C. Powers to issue directions for interception or monitoring or decryption of any information through any computer source under Section 69, power to issue directions for blocking for public access of any information through any computer resource under Section 69A, power to authorize to monitor and collect traffic data or information through any computer resource for cyber security under Section 69B, unauthorized access to protected system under Section 70, penalty for misrepresentation covered under Section 71, breach of confidentiality and privacy under Section 72, publishing false digital signature certificates under Section 73, publication for fraudulent purpose under Section 74, act to apply for offence or contraventions committed outside India under Section 75, compensation, penalties or confiscation not to interfere with other punishment under Section 77, compounding of offences under Section 77A, offences with 3 years imprisonment to be cognizable under Section 77B, exemption from liability of intermediary in certain cases under Section 79, punishment for abatement of offences under Section 84B, punishment for attempt to commit offences under Section 84C, offences by companies under Section 85. Note: Section 78 of IT Act empowers police inspectors to investigate cases falling under this Act. Sending threatening messages by email under Section 503 IPC, word, gesture or act intended to insult the modesty of women covered under Section 509 of IPC, sending defamatory messages by email under Section 499 of IPC, bogus websites, cyber frauds under Section 420 IPC, email spoofing under Section 463 IPC, making a false document under Section 464 IPC, forgery for purpose of cheating under Section 468 IPC, forgery for purpose of harming reputation under Section 469 IPC, webjacking under Section 383 IPC, email abuse covered under Section 500 IPC, punishment for criminal intimidation covered under Section 506 IPC, criminal intimidation by an anonymous communication covered under Section 507 of IPC. When copyright infringed, copyright in a work shall be deemed to be infringed covered under Section 51. Offence of infringement of copyright or other rights conferred by this Act, any person who knowingly infringes or abets the infringement of under Section 63, enhanced penalty on second and subsequent convictions under Section 63A, knowing use of infringing copy of computer program to be an offence under Section 63B, obscenity under Section 292 IPC, printing etc. of grossly indecent or scurrilous matter or matter intended for blackmail under Section 292A of IPC, sale etc. of obscene objects to young person under Section 293 IPC, obscene acts and songs under Section 294 of IPC, theft of computer hardware covered under Section 378, punishment for theft covered under Section 379, online sale of drugs covered under NDPS Act, and online sale of arms covered under Arms Act. Chapter 9 of IT Act 2000 covers the penalties, compensation and adjudication for cyber offences like damage to computer system by means of unauthorized access, unauthorized copying of data, spread of viruses, denial of service, that is DOS attacks, disruption of computers, computer manipulation under sections 43, 43A, 44 and 45, which attracts civil liabilities by the way of compensation. Those cyber crimes which were not covered under sections 43, 43A, 44 and 45 can be tried under normal, civil or criminal court. For the purpose of adjudging under Chapter 9, a special person called adjudging officer has to be appointed by centre or state government. On 17th March 2003, Parliament passed the Information Technology, Qualification and Experience of Adjudicating Officers and Manner of Holding Enquiry, Rule 2003, which specifies the qualifications required by the adjudicating officer. Adjudicating officer will be responsible for cases related with unauthorized access, unauthorized copying of data, spread of viruses, denial of service attacks, disruption of computers, computer manipulation, etc. Central states are liable to appoint Secretary of Department of Information Technology of each of the states or of Union Territories of India as the adjudicating officers. Every adjudicating officer has power of a civil court, and all proceedings before him shall deemed to be judicial proceeding within the meaning of sections 193 and 228 of the Indian Penal Code 1860, and it shall be deemed to be a civil court for the purposes of sections 345 and 346 of the Code of Criminal Procedure of 1872. Parliament also passed the Cyber Appellate Tribunal, Salary, Allowances and other terms and conditions of service of chairperson and members rules in 2009, and Cyber Appellate Tribunal, Procedure for Investigation of Misbehavior or Incapacity of Chairperson and Members rules in 2009, which states the establishment of Cyber Regulations Appellate Tribunal or CRAT at a national level to hear appeal against the order of adjudicating officer. Cyber Regulation Appellate Tribunal has powers vested in civil court under Code of Civil Procedure. Central government has set up first Cyber Regulations Appellate Tribunal, CRAT, in New Delhi. Cybercrime cases are increasing day by day in India. Data released by National Crime Records Bureau or NCRB on cybercrime stated that total of 11,592 cases were registered under cybercrimes, which includes cases under Information Technology Act, offences under related sections of IPC and offences under special and local laws, that is SLL, in the year 2015 as compared to 9,662 cases registered in the year 2014, which shows 20.5% increase in cybercrime as compared to the previous year of 2014. Uttar Pradesh registered 2,208 cases, followed by Maharashtra registered 2,195 cases and Karnataka registered 1,447 cybercrime cases. Out of 11,592 cybercrime cases registered, 8,121 persons were arrested in the year 2015 as compared to 5,752 persons arrested in the year 2014. A total of 2,396 cases were charge sheeted during the year 2015. A total of 4,191 cases were pending for trial at the end of the year 2015, in which maximum number of cases were computer-related offences during the year of 2015. In 486 cases, trials were completed. 193 cases ended in conviction. Despite cybercrime cases being registered in large number of cybercrime cases across the country, there is a lack of available judgments by adjudicator of all the estate under sections 43, 43A and 45. Maharashtra Adjudication Officer has good record of disposing cases, as he has disposed 51 cases out of 71 cybercrime cases under IT Act. Some landmark judgments in cybercrime cases in India I will be discussing over here now. The very first case is of the Sony.Sambandh.com case, a first cybercrime conviction in India. Sony India Private Limited runs a website, that is Sony.Sambandh.com, which offers NRI to buy Sony products and send it to their friends and relatives in India. One such client, identified as Barbara Campa, ordered and requested to deliver Sony TV and cordless headphone to Arif Azim of Noida by making credit card payment. Later, credit card agency informed about the unauthorized transaction, as credit card owner denied that she has made the payment. Sony India Private Limited had lodged the complaint for online cheating, and Central Bureau of Investigation had investigated the case and arrested Noida-based call center employee Arif Azim. Arif Azim had gained access to credit card number of American national for credit card payment and misused Sony company website. CBI recovered Sony TV and cordless headphone as evidence, and the court found Arif Azim guilty under section 418, that is cheating with knowledge that wrongful loss may ensue to person whose interest offender is bound to protect, under section 419, that is punishment for cheating for personation, and under section 420, that is bogus website and cyber fraud of the Indian Penal Code or IPC, and convicted him for this crime. But later, court felt that he was first time convict and 24-year boy, and released Arif Azim on probation for 1 year. This was the first such cybercrime case in India where court convicted the accused. The second case, that is the ICICI Bank case, a first landmark judgment by adjudicator. Mr. Umashankar got email from ICICI Bank asking him to reply with his internet banking username and password, otherwise his account would be closed. He replied with internet banking credential details, and he found rupees 6,46,000 transferred from his account to one of the company, and rupees 4,60,000 withdrew from ICICI Mumbai branch. Actually, the above email was phishing email pretended as an email from the ICICI Bank. Mr. Umashankar filed an application to State IT Secretary of Tamil Nadu for adjudication under IT Act of 2000 and held ICICI Bank responsible for his financial loss. There is no such system existing that the customer could identify that email is from ICICI Bank or not, and so adjudicator of Tamil Nadu found bank guilty for not following the security measures for such things, and in landmark judgment by adjudicator of Tamil Nadu in this case, which directed ICICI Bank to pay rupees 12,85,000 as compensation to the petitioner Mr. Umashankar. Next is the first conviction under IT Act of 2000. An accused posted obscene and defamatory message about a divorcee woman on Yahoo message group, which resulted in annoying phone calls to divorcee women. Investigation was carried out based on the complaint made by the victim, and after tracing out originator of obscene messages, it was found that the accused was from Mumbai and a family friend of victim and was interested to marry her. But she married another person and later divorced. Accused again tried to marry her but failed to do so and started harassing her through internet. The accused was found guilty under section 469 of IPC, which is regarding forgery for purpose of harming reputation, under section 509 IPC, that is word, gesture or act intended to insult the modesty of women, and under section 67 of IT Act 2000, that is for publishing or transmitting obscene material in electronic form, and sentenced was given to accused for rigorous imprisonment for 2 years under section 469 and 1 year simple imprisonment under section 509 and 2 years rigorous imprisonment under IT Act 2000. This was the first conviction in India under IT Act 2000. The next case, fine to complainant for submission of fabricated evidence. Application was filled by one of the company from Ahmedabad against one of his employee as respondent that respondent has carried out unauthorized copying and selling and has transferred confidential file to his personal email ID. Complainant had submitted confess letter of respondent on affidavit as only evidence for claiming his allegation, and that evidence was challenged by the respondent. Meanwhile, complainant requested for withdrawal of case. An investigation revealed the submission of fabricated evidence by the complainant. Adjudicator officer of Government of Gujarat agreed to withdrawal of case and directed the complainant to pay rupees 15,000 to the respondent for the damage incurred by him and further asked to pay rupees 10,000 as a fine. Next is the first conviction under IT Act in Kerala. Priest T.S. Balan and his son Anish Balan from Kerala morphed photographs of Pastor Abraham and his son Walson Abraham and daughter Starla Luke and emailed them from the fake email ID. The case was filed by victim, and after investigation, both accused were found guilty by court for morphing, emailing nude photos of Pastor Abraham and his family. Additional district and sessions judge sentenced them for 3 years rigorous imprisonment and rupees 25,000 fine under section 67 of IT Act, publishing or transmitting obscene material in electronic form. 6 months rigorous imprisonment under section 120B of IPC, that is for punishment of criminal conspiracy, and 1 year rigorous imprisonment and rupees 10,000 fine under section 469, that is forgery for purpose of harming reputation. The next case, that is the case of life imprisonment to Dr. L. Prakash, a 50-year-old doctor, made porn file with one of a young man by promising him to circulate movie only in selected circle abroad. But Dr. Prakash posted the pictures and videos of that young man on internet. The young man approached police after finding his porn video on the internet. After investigating, police found that Dr. Prakash and his brother, both settled in US, had 1 lakh shots and video footage of this alike. The fast-track court judge convicted all 4, that is Dr. Prakash, Saravan, Vijayan and Asir Gunasingh. Court imposed rupees 2,500 to each of his associates and sentenced Dr. Prakash for life imprisonment and also imposed rupees 1.27 lakh as fine under Immoral Trafficking Act, Arms Act and Indecent Representation of Women Prevention Act. The next case is of Kumar versus Whiteley. Mr. N.J. Arun Kumar, a techie from Bangalore, gained unauthorized access by means of hacking to the Joint Academic Network, that is the JANET, using BSNL internet connections and made alteration to broadband internet user account, computer database and later changed password of BSNL internet account connections, which incurred a loss of rupees 38,248 to the subscribers. Chennai court found N.G. Arun Kumar guilty for this wrongful act and sentenced 1 year rigorous imprisonment with rupees 5,000 fine under section 420 of IPC, that is for cheating, under section 66 of IT Act, that is for computer related offences. Cybercrime has global character with the availability of cheaper smartphone and easy access of fast internet. There is an increase of internet and social media users and cybercrime at the same rate. Besides cyber law, people should also be aware about cybercrime and cyber law, and companies should be serious about implementing information security system at their organizations to protect the confidential data. There is lots of difficulty before investigating agency due to technical and jurisdiction hurdle and varying nature of cybercrimes due to enhancement in technology. Cybercrime affected person should get complete justice and criminal should get highest punishment, which will anticipate the offenders of cybercrime. Dear students, this is the end of our conclusion, in which we have recapitulated our chapter Adjudication of Cybercrimes in India. I hope you all have enjoyed this lecture and gained valuable knowledge. I hope you all have understood the underlying concepts of this chapter. Do keep in mind what we discussed today. I'll be back with one more lecture in this series. If you want to learn more and enhance your knowledge, you may log on to our website www.cec.nic.in for MCQ quizzes, LORs, etc. Make sure you revise the modules frequently so that you master the topic well and take up the exercises. Thank you for your time today. I'll see you in the next lecture. Keep learning and goodbye.